Welcome back to Alchemy Xtra. I'm speaking to Des Carty as part of our series of interviews discussing the book Irish Life and Me, Tales of the Criminal Cabal. And we're up to chapter 6, but before we get to it, Des, we're going to recap on what we were speaking about up to now. First off, though, how are things?
Grand, yourself?
Very good, thanks, and good to have you back. I'm really enjoying this series of chats, I must say.
Good. What's today's date, John? Just to let people know when we're doing it. I think it's, what are we on now? The 14th of November, is it?
Yeah, November 14th.
Yeah, grand. Just keep it in context for people. It's November the 14th, 2013. And the reason I mentioned the date, basically, is because we're basically coming on a year and a half, I think, of the engagement of this process, as we describe as being in Irish Life and Me. And back in February, March of 2012, this whole process started when, if you recall, the man, Tom, received his first letter from Irish Life and Me, and then he responded in respect of sending them in a data request. He didn't get an answer to the data request. And then he went on to speak and write to the regulators. He wrote to the regulators, and he also wrote back as well to Irish Life themselves in relation to their threatening and asking letters. And then to cap that off, the last time we spoke about what he issued a notice to the regulators in relation to breaches of or not breaches, but in relation to questions that were asked in of the regulators and of the bank in relation to the Central Bank Reform Act 2010. And just to bring everybody up to date, there was no response to any of those letters, including the data request. And that would bring us up then to chapter 6. Now, obviously, there had been a few letters back and forth. I think most of them are covered in the book. There may have been one or two that were left out just to get, I suppose, to progress with the book. But primarily, the readers and the listeners will have all the information that they would require if they were being threatened by any of the banks. This is just not just applicable to Permanent TSB or Irish Life, but to any of the banks. So the processes we're describing, John, would be applicable to any man or woman that is being threatened with losing their home or their, I suppose, residential investments, or even in some context, commercial investments that they had made, property, land, so on and so forth. So the same questions can be asked, and especially if you're dealing with, I suppose, the bank. And more certainly, the same questions could be asked of the regulators or the watchdogs, as they're called. So that would bring us up to chapter 6. And within chapter, if you want to, do we want to talk about chapter 6 now, John?
Yeah, I think let's delve straight into it.
Did you get any questions during the week via the YouTube video, or I know we didn't get many questions in relation to Irish Life and Me?
No questions per se. Got some feedback, all right. Very positive feedback. People are finding the series of interviews very clear and concise, and particularly when read in conjunction with the chapters, so that people can see what we're talking about as well. People seem to find that very helpful. So that's something I'd certainly recommend to anybody who might be listening for the first time. Get your hands on the chapters. And Des is going to tell us how we can do exactly that, because it will certainly help you get a better grasp of what we're speaking about when you have it straight in front of you as well.
Well, very simply, John, they can go to irishlifeandme.com, and they can either procure a hard version of the book, a printed copy, or as we're releasing the chapters, they can download the chapters one by one. I think we're on chapter 5. Chapter 5 has been released. Next week we'll have chapter 6 and hopefully chapter 7 available for people to download. But again, we'd like to see people do this piecemeal, so that they take on board and perhaps even carry out their own exercises in relation to writing to the banks.
Yeah.
All these things are legal. They're above board. It's what you're legally entitled to do. So there's no issue here in relation to you acting outside legality or outside of the law. Okay, so chapter 6, it primarily focuses on what we call the follow-up. So up to this point, we had written, as we said earlier, to the bank seeking all the data and information under the Data and Information Acts, i.e. that would be the Data Act 1988-2003, and also the Freedom of Information Act 1997, but that's quoted in the book as well.
Yeah.
So under those acts, you're entitled to all the information that the bank have on file about you, about the property, so on and so forth, any information whatsoever, and they cannot be seen anyway to withhold any information. So the date here, let me just check the date on this, John. Yeah, up to the 11th of May, we hadn't, Tom hadn't received any information, data and information from Irish Life and Me for, we cannot actually say why, but we suspect it's because he started asking questions that they weren't prepared to answer. So again, they cannot withhold any information they have on file. So if Tom had gotten the information up to this point, he would have had to have received also a copy of any letters that he had sent as part of that data disclosure. And of course, I don't think they wanted to formally disclose that. So again, if people do get a response from the bank in relation to the data request that they have sent in, then they should, just as a matter of course, and I don't think we mentioned this in the book, but that's why I want to mention it now, they should, as a matter of course, respond to that letter and that data that they have sent and log the information, i.e. write down a schedule of information that they have received in whatever detail they can manage, and then send that as a letter back to the bank to notice them or give them notice that you have received this specific information. Now you have to be quite specific in relaying back to them what you have received.
Yeah.
That then will legally preclude the bank from bringing in any further evidence. So if you have sought the data and information, and say, for example, you follow it up with a letter to say, I also want to see an attested copy of the alleged contract, or an attested copy of the alleged mortgage, so on and so forth, or any other documents like that, then they have to legally give them to you. And if they withhold them, if they withhold those documents, then they're deemed to not exist. So they're precluded then from bringing them in a court of law, if it comes to that.
So you've got a real weapon then if they start ignoring you at this point.
Oh, absolutely. I mean, during the week we were dealing with a few issues here whereby people weren't getting information from various different companies. And whether or not the companies realized it, they were actually shooting themselves in the foot by withholding information. And again, withholding, stifling, suppressing, or interfering with evidence, i.e. information, is a criminal offence. So again, we kind of had them here. They didn't want to give us information. They didn't want to give Tom any information because he had written letters about these alleged mortgages and contracts and so on and so forth. And because they didn't enter into a dialogue with him, they didn't want that, I suspect they didn't want that to be known to, obviously, us, him, and other parties, i.e. the regulators. Now, as well as that, Tom also directed the regulators he also directed the bank that should they send him information, any information whatsoever, that they were, by his direction and under his terms and conditions of his letters, to copy that information to all parties that were now involved. And as you're aware, there's quite a list of parties that are now involved, including the regulators and the Minister of Finance, Minister of Justice, so on and so forth, and Chief Justice. So again, they didn't want to go to that trouble, obviously, and they didn't want this to become an open wound for them as well, because anything they said then could then be held against them. So this is one thing people need to remember. We see letters every day coming through the door. Now this is on topic of what we're talking about, just so as everybody is aware. But we see letters coming through every day from people asking us to review letters, so on and so forth. And the one thing that people keep doing consistently is they keep incriminating themselves in their letters by making statements. So again, just to reiterate this for your listeners, John, they need to think critically, and by reading the book as well, you'll also pick up on the sort of and form of letter writing that you should consider using, whereby you're not making any statements whatsoever. And one of the key exercises that will help you do that is to try and construct questions without using the word I. Now, it doesn't really matter that much if you do or don't use the word I, but it'll actually help you remove yourself objectively from the issue if you refrain from using the word I, as in I did this, I did that. Yeah. So people have a habit of saying, well, it's my mortgage, I took it out, I must pay my debts. So that immediately incriminates yourself, as opposed to asking questions about, well, what debt are you talking about? What alleged debt are you on about? Can you demonstrate to me that there is a debt and that I am a debtor?
Yeah, because
or that we are debtors.
it's important to note that from the offset, we're questioning the alleged validity of the alleged mortgage or debt or whatever it is. So if at any point suddenly we say that, well, yeah, this is my mortgage, that is incriminating. So I think that's something people need to be very, very careful about.
Absolutely, and there's retroactive or retrospective legislation being brought out in relation to PIP's mortgage. You know, these guys that are now going to be helping the banks and helping people allegedly. And if you read the legislation, the most recent legislation of 2012-2013, again, they categorize primarily. They try to categorize people as being debtors, whereas when you get to know the money system and the way this thing is operated, you'll realize, it may take you a while to get your head around it, but you'll realize there's a very valid question to be asked there as to whether or not you're a debtor or a creditor. Now, we have had cases withdrawn by banks because simply they have failed and refused and neglected to answer those simple questions. For example, we've asked several banks, through people that have obviously come to us, simple question like, who owns this account? And prior to that question being asked, the bank would infer or intimate that you're the one that owns the account, it's your liability, blah, blah, blah. But again, the question we'd have is, well, if you ask the bank who owns the account, that's a simple question, and anybody can do it. Who actually owns that account that the bank have created? Because you didn't create it. You didn't create the account number. Who did, first of all, and then who owns the account? And the bank will never answer and say that you own the account. Well, they haven't so far. Maybe they will in the future. They haven't categorically stated or stipulated to any people that we work with that you own that account, simply because we don't think you do.
Yeah.
And they won't answer that. And you see, they can't either, because you see, if you don't own the account and they say you do, that then is a lie. Call it what it is, and it can be perceived as perjury in the court as well if it's proven that you don't own the account. So they're very reluctant, the banks, to state to you that you own that account, whereas in fact you don't own the account. What you're doing, in fact, at some stage, is you're allegedly managing that account, and they employ you more or less as an employee to do so. In other words, you're employing you to make money for them, and that's the purpose of managing an account. So you're an unpaid employee, basically, i.e. a financial slave, essentially, when you manage an account for a bank. So, all right, look, that's kind of off topic itself, but Chapter 6 is called the follow-up, and what it is, basically, it's just to reiterate, and it was a letter that was sent again to Irish Life, to reiterate the fact that they had not followed up on the data request. They had not sent any information in under the Data Protection Act. So, again, just to reiterate, there was 4 things that were noticed to the bank, and that's on page 70 or so. The summary of the 4 points is that the letter that was sent in relation to noticing them or giving them notice that they had not forwarded the data that they were directed to do so, and they were paid for. They were given money to do so, as in 635, the statutory fee. The main 4 points are: it notices their breaches and contempts. Words where they did write, or if they did write, they didn't copy any of the parties. They didn't answer any questions that were sent in. And secondly, it demands proof of any alleged legal standing. So it's looking for the bank to establish what legal standing they now have if they are failing, refusing, and neglecting to give information over that which they may later rely on in court. Does that make sense?
It does. So basically the bank have acted or failed to act, and you're now copper fastening what the ramifications of that are for the bank.
Correct. So it was looking, again, just to reiterate that, John, Tom was demanding proof of the alleged legal standing. So because they didn't send in or send back the data that they were requested and paid to do, it's not as if this was done for nothing. They were paid to do it, a statutory fee of $635. And then thirdly, noticing that anything they rely upon will be scrutinized, examined in detail. So again, just to let them know that anything they had, if they were sending anything in, not that they had, it would be forensically examined. In other words, we'd leave no stone unturned in examining any information that they sent, but they didn't send any. So that again puts them on the back foot slightly.
Yeah.
And then fourthly, it gives them a legal time limit in which to submit alleged proofs that they may wish to later rely upon. So again, it gives them a final, I think it was a final 14 days, or sorry, it was 10 days, in which they could forward on the information. Again, the letter was copied to all parties, noticing everybody. And at this stage alone, the Data Protection Commissioner should have been in there like, I don't know, like a fly on so-and-so, looking at this and examining this. But again, the Data Protection Commissioner sort of stood back and did nothing. So will I read out a bit more detail, John, in relation to those 4 points? Or will we...
that'd be good, I think.
Yeah. Okay, so the letter is quite clear, but we've restated the letter in text here on page 71. It says, for the record, we have noticed that you have failed, refused, and neglected to forward any of the data demanded of you of the 4th of April, 2012, under the Data Protection Act 1988-2003 and the Freedom of Information Act 1997. You are now in breach of these acts and are now subject to investigation by the Data Protection, the Freedom of Information Commissioner, and National Consumer Agency's offices. It will be in your best interest to comply and cooperate with these investigations. So not forgetting again that the Data Protection Commissioner, the Freedom of Information Commissioner, and the National Consumer Agency had a copy of this letter. All of those three parties, commissioners, agencies, failed to act upon this information. And they had been written to directly, they had been corresponded with directly, so on and so forth, as per the letters in Irish Life and Me, and they still neglected to actually act and carry out their duty. More to the point, they didn't operate under their duty of care to Tom to investigate these matters. Now, Tom could have put in a complaint which would have probably set off some sort of a formal investigation, but we said to Tom, look, leave that aside, because they still have a duty of care under their own acts if they suspect something untoward is going on, and you have given them plenty of information to allow them or to give them facility to investigate. Now, if they fail to do that themselves, they're still in breach of their own duties of care. So that's good to remember for everybody. This is why we don't put in formal complaints to these commissioners. There's another reason for that also, is that if any of the commissioners find against you, it's like having a court. It's almost as analogous to having a court. So that will go against you at a later date. If the Data Protection Commissioner turns around and says, well, actually, they did nothing wrong, which the likelihood is they may do that, given that what we know now, then that will go against you in the court of law. And similarly with the National Consumer Agency, same with the Ombudsman as well. If the Ombudsman finds against you, that is actually more or less a court of law. So that will go against you if you ever end up in front of a judge on another issue. So the next point was, we demand that you forward us proof that you are a legal, real party of interest. So we wanted to know, or Tom wanted to know, are these people, the PTSB, Life, Irish Life, so on and so forth, are they the real party of interest? Have they got a direct interest in this matter? And how so? Because, again, we suspected at that time that Irish Life, Permanent TSB, had sold on the alleged mortgage-stroke contract. It's called securitization.
Yeah.
So what right would they have to sue if they sold on the alleged alleged contract? In law, you cannot sue if you sold on something you haven't. Therefore, you lose the right to sue. It's that simple.
Okay.
It's like going to a pawnbroker, giving them the blankets for the money, and the pawnbroker goes and sells the blankets, and then he still wants you to pay him back the money. Well, he has no right to ask you for the money because he doesn't have the blankets anymore.
Yeah.
So it's that simple. So that was the question there. Then the third point was, remember, any documents you forward as evidence of proof will be subject to legal lawful scrutiny pursuant to securitization and the audit. So again, we were hopeful actually they would send something back, but they didn't. Would this give them notice that should they send anything back, then we would open it up to further investigation, as in a securitization and a solvency audit, which legally Tom has the right to do because they're making allegations and they're providing alleged evidence. So then he has the right then to further investigate that alleged evidence that they put on the table. This is very analogous to a criminal case, if you like, or a summary offence, whereby if they forward evidence, you then have the right to examine the evidence and look for and seek further evidence to support what they have on the table. So they knew that then, that Tom was deadly serious about this. Then the final point here was, if we do not receive proof within 10 days of the date herein, it will constitute your lawful admission that you are not the real party of interest in this matter, and you have no legal standing in said matter. This document will be used as evidence under the rule of discovery.
And
so
again, I think it's worth just interjecting there, Des, to remind people that's quite a powerful statement, because a rule of thumb that's applied within the law is that ignorance is no defence, and that applies equally for the banks or somebody who might be trying to get you on the hook, a solicitor, whoever it is, as it does for you as an individual. So you can use that tool that is used against you all the time, against them also.
Absolutely, that's very well put, John. And it applies for all of law. Anything that they're doing to you, you can do it back to them in spades. It's that simple. So people need to get their head around this. Anything they can do, you can do better. It's quite simple. Now, the other thing to add to that as well, and this is the analogy I think we made before, and this is the analogy we give to a lot of people, is that the banker when you engage with a bank in relation to this type of engagement, it's like trying to walk into a boxing ring and you're confronted with a heavyweight world title holder, like Mike Tyson was, or I don't know who the world heavyweight boxing champion is at the moment, but you're faced with a world title fighter. But you just have to remember this: you're not to walk into the ring until you're ready, first of all. And second of all, all boxers that operate and have world titles, they have to operate under a set of rules and principles, and they're called the Queensberry rules. Now, I think they still operate under those, which means they can't punch you in the back of the head, they can't punch you in the kidneys, they can't kick, they can't bite, they can't do all those sorts of things. So they have a set of rules that bind them, and the referee has to impose those rules. Now, the trouble is, of course, when you walk into a ring, or into court, we'll use the court as the analogy here. First of all, people don't know the rules to start with. Most people just don't know the rules. Second of all, generally, because of the way the system is set up and structured, there is no referee that's objective there. They have what's called a judge, and he's perceived to be objective, but in reality, if people observe what happens in the courts, they'll see, well, the judges aren't that objective, and primarily they're not. They don't really help defendants. They don't really help people that are being attacked. So you're walking into a ring with a heavyweight title fighter, which is probably a barrister stroke a solicitor. There is no real objective referee, and you're a man that's walked in off the street and you don't know how to box. Okay?
Yeah.
So you don't really stand that much of a chance if you walk into that ring in that context. So what we're saying to people is, before, if possible, you ever get near the ring. Now, there's ways of dealing with it if you're perceivably in the court. There's ways of dealing with that as well. But the point here was to see, Tom was prepared to go into the ring. Okay, psychologically he was prepared to do that. That wasn't an issue. And we clarified that with him early days. So, what people should, I suggest in the analogy of the boxing ring, people should walk around the ring for a while. Okay, and suss out the different characters that are around the ring, and engage with the characters that are around the ring, and i.e. the bank's representatives, the bank's solicitors, blah, blah. These are all the characters that are not in the ring, because the banks send in their prize fighter, the barrister, into the ring. They don't send in the bank manager, and they don't like sending in bank managers. So what we're saying to people is, what you can do is, while you're skirting around the ring, you learn how to fight. Okay? Now, you should learn how they fight, learn their rules first. And boxing rules are quite simple. It's the same with any rules of any game. The rules are generally very simple. Now, they're not allowed to break those rules once the ring and once the fight is on. They're not allowed to break those rules. And this is what we're pointing out here. These rules cannot be broken. And if they are broken, you can use it against them all the time. But what people should remember also is that you can learn their rules and the way they fight, and you can observe that, and that's not difficult to do. You can walk into the court any day of the week, you can sit there, you can observe, and that's a good exercise, it's a good lesson.
Yeah.
Now, people can also then create their own rules of the way they want to engage and fight. It's that simple. So when you're looking at your alleged paperwork or whatever it is, you can look at it from a certain objective, and then next week you can change the way you look at the paperwork if you get new knowledge or different knowledge. So starting this process off is very simple. And as you go, you'll gain the knowledge in which to attack them. And you're attacking them long before you get into the ring as well. You're disengaging them. And you're giving them stuff whereby they have to deal with this stuff before they get into the ring. And very often, if you get the right stuff into your head, they won't want to go into the ring, just in case you throw a kick or a headbutt that they can't deal with. And that's what you're allowed to do as a defendant, if you like, as a lay litigant. Because, again, going back to the eye of the ring, if you walk in there with a solicitor, the solicitor is you, and the solicitor is going to get hammered. But the solicitor doesn't mind getting hammered because he's paid to take the fall. And that's it. So I don't see any point of engaging with solicitors. Now, there may be solicitors, again, that are out there will be genuine and want to do right by their clients, but primarily we don't see them. So again, I'd hold tight to the boxing analogy, because again, you should learn their rules, but also bring in your own way of operating, your own terms and conditions. And that, I suppose, that's the message for that chapter. Now, again, the final notice demand was also sent in. We sent in, obviously, the follow-up for the data request. They didn't respond. We didn't think they had any intention of responding. Then, after that, John, we sent in a final notice demand in relation to the fitness and probity questions, which, if you remember, we covered in Chapter 5. And this, very simply, is dictated to the bank. They were in breach of the Bank Reform Act, and that they hadn't answered the questions. And there was a couple of things there at the end of the letter, of that letter we sent in, or Tom sent in. We gave them 72 hours because Tom was a reasonable man, and he gave them 72 hours to finally answer the questions. But of course, they didn't. But he threw in a few punches as well in that, which people can read for themselves. And he did say on the letter that as a sort of a parting gesture to them, he stated, by tacit procuration, in other words, if you don't respond, you are agreeing.
Yeah.
Okay. So silence is acquiescence. In other words, if you keep your mouth shut, if they kept their mouth shut, they were agreeing to what Tom was saying. So he said, by tacit procuration, you are agreed that you are guilty of fraud and extortion. Okay?
Okay.
So he was levying a pretty strong attack upon them. So that was like, if you want to call it a headbutt, without going into the ring. He was headbutting the bank, for lack of a better description.
Yeah.
So again, he stated, you are agreed. So they, by not responding, and him giving them another 72 hours to respond to the fitness and probity questions, he's stating, you are agreed that you are guilty of fraud and extortion. Now, if they were not guilty of fraud and extortion, why didn't they come back and answer the questions?
Well, I mean, that's a very good question, and it's one that I wouldn't like to be asked if I were them in court. Okay, so just moving on from that, again, just to give people a legal idea, a good legal idea, you can when you're writing letters, you can put down 7 days, 40 days, 21, 30, whatever amount of days you want. Again, your terms and conditions, you dictate what amount of days you want to give the bank in terms of getting responses and answers. Well, legally speaking, all you have to do is give them 72 hours. Okay? Okay.
So people should remember that 72 hours is the accepted legal minimum that you can give anybody to answer your questions or to send you the data and information, so on and so forth.
Right.
So that's really, I wouldn't worry about the time frame. If you're reasonable, you'll be saying to them maybe 7 days, 14 days. But if you want to be really tight on it, you can say 72 hours. And then by them not answering, they've agreed. So again, we'd go for 3 strikes and you're out. It's a bit like in the States, if you commit a crime 3 times, you're in jail.
Yeah.
So that's the way we operate. Now, just to add to that, we've added in a couple of bits to the chapter. And it's just a point of note, really. At the time of writing, we did do a little bit of research. And don't forget now, Patrick Honohan, the head of the central bank, and Matthew Elderfield, the head of the financial regulator, were there. Matthew Elderfield has since moved on. I think he's got a job at McDonald's or something like that. And Patrick Honohan is still there.
Okay.
So Patrick Honohan, at the time of writing, and I think this is still true, Patrick Honohan has had a very interesting history in relation to his career. He worked for the International Monetary Fund, so he'd be familiar with the comings and goings of the IMF. He worked for the World Bank, Okay, and these things will have different meanings to different people as they're hearing this. But he worked for the World Bank. He worked for the London. Sorry, he was at and attended, and I think he worked for the London School of Economics. He also worked for the Bermuda Monetary Authority, the UK Financial Services Authority, the London Investment Banking, LIBA, and the British Bankers Association, and the Washington-based DC, which is a Washington-based DC-based firm called the Institute for Strategic Development.
Presumably, he also has a very good relationship with Satan.
Well, look at you might say that, and I'd probably agree, but it just gives insight into where this man is coming from. Now, we have information as well about the central bank, but we didn't put it in this. But there is an authority also in Ireland called the the Institute for Commerce in Ireland, and Patrick Honan's father set that up. So you can see, again, we were talking about criminal cabals. Honahan's family are tied up in financial cabalism, if you like, and have been for probably 2 or 3 generations. So, again, just to point out this, Patrick Honahan was and is on the board of the IMF and still is, as is Michael Noonan. Now, just as a point of interest, we also did a little bit of research on Michael Noonan, and this can be found on the Oireachtas website anyway. But Michael Noonan himself is a German bank bondholder. Okay? So I don't know if that's news to people, because you can actually see this is information that he's declared. So Patrick Honahan and Michael Noonan are on the board of the IMF, and Michael Noonan is a German bank bondholder. Now, that itself raises some serious questions, as to how is it Michael Noonan, who's supposed to be objectively representing people of this island, is on the board of the IMF, first of all, and is a German bank bondholder.
Well, to me, as a layman who knows nothing, it seems like a complete conflict of interest.
Well, but that's what we were, people can draw their own conclusions from this, and it's just worth investigating these things to see where these people are coming from. So, if nothing else, I don't know if the IMF are paying Patrick Honan. I don't know if they're paying Michael Noonan. I know that as an investor, a German bank bondholder investor, Michael Noonan will be getting something from that. And I don't know if he bought those bonds or if he was giving them free of charge. I don't know how he got them, so on and so forth. Maybe that's worth somebody's time investigating to see where he's come in that respect. Yeah. But it opens up the thought, well, these people are not objectively looking at these things. There is some issue there in the background. They should not have best interests in things like the IMF and German banks. If they're trying to deal with the economy of Ireland, they should be independent. Now, again, just to point out to people, the Central Bank of Ireland is not, it's a privately owned operation. People should be aware of that. The Central Bank of Ireland is not a state institute. And it's not answerable to the state either, because we did investigations into that. So the Central Bank of Ireland do not have to account to the state.
That's really big news. It's startling news, I would imagine, to a lot of people. I remember when I first heard it, I was astounded by it. All this information is such good information, and it's so powerful because, as demonstrated, and we'll see more and more of it as we go on in the book, all of it can be used to protect and defend ourselves against these malignant forces that are attempting to, well, you can use whatever word you want. I would use the word extort money and energy and everything else from us, and just basically to enslave us in an economic sense.
Yeah, well, that's it. Look, as a people, we are not answerable to the banks, and we're not answerable to the state either, for that matter. I mean, just to sort of get to the end of this chapter, basically the state, in its guise of whatever it is, with the politicians and the different civil servants, if they were operating the way they're supposed to operate, they'd be saying to the people, lads, like, what do you want us to do next? They wouldn't be saying, here's the next bit of legislation we've decided to impose on you to increase the taxes.
Yeah.
They'd be saying, lads, what do you want us to do? Tell us what you want to do. And as your administrators that you employ us as administrators, we're told as a good employee. Because that's exactly what they are. They're nothing else. They're nothing more. It's the same with the judges. It's the same with the councils. It's the same with all state bodies, semi-state bodies. These are administrators that are supposed to be administrating the business of the state on behalf of the people.
Yeah.
And they don't. All they do is rape, plunder, pillage to extract revenue from the people. And I just don't get why people, now I'm not on a rant here right now, John, but I don't get why people don't see this. Because day to day, now again, I understand why people don't see it, but I just sometimes don't get it. I get frustrated with it. That they should be looking, people should learn to look at this critically. The state are there, ideally, to do what they're told to do, not to sell off the resources of the island of the people that own the resources, and then to enslave them financially with taxes and debts and burdens. I mean, I don't know, recently there was a referendum, I think it was in Switzerland. I'm not sure of the actual country, but I think it was Switzerland. And the people voted to give themselves a pay rise. And each man and woman in Switzerland, I think it was Switzerland, got €2,000 a month pay rise. So they all got an extra 2,000 spending money through the state because they agreed, yeah, we deserve it.
Yeah. And
that's the way it should be on this island. I think anyway, that's my approach, that the state regulators and bodies should be saying, lads, what do you want next? What do you want us to do next? How do you want us to distribute your wealth? Or do you want to just give it over to the IMF? So we've a lot to learn. There's a lot of people out on this island have to wake up to this. And eventually I'm hoping that everybody will wake up to it and turn around to the politicians and the states and the state and the regulators and all this. Say, lads, sorry, if you don't do what we tell you, you're out of a job. It's that simple.
Yeah.
You know?
Well, as you say, there is a lot to learn, and we will be learning more and more as we progress through the book. And any kind of a last thought to just tie up Chapter 6, because we've a big chapter ahead of us with Chapter 7 as well next week.
Yeah, I'm hoping. Last thought. No, I think everything is hunky-dory there. Just to summarise again, the Chapter 6 just reflected upon the fact that the banks up to that date had not responded in terms of sending any information, any data, any evidence, and they were being put on notice all the time that, lads, if you don't send us this stuff, you can't use it in the future.
Yeah.
Now, as we'll see later in Chapter 7, things hot up because they obviously are not happy with Tom writing his letters, and they take issue with it, but we'll expand upon that in Chapter 7.
Brilliant. Well, looking forward to speaking. Thanks again for this week, Des, and we will, of course, speak again next week.
Come in, John. Take it easy.